Fintech founders love referral programs for the same reason that regulators are often skeptical of them. Incentives work. If you are offering an interval fund direct to consumer, especially on a self-distributed model, a well-designed incentive program can be your most efficient acquisition channel. The wrong program or the right program implemented the wrong way can create problems fast. Unregistered broker activity, improper compensation solicitation, and RAA marketing rule violations, often all at once. This video is meant to help you spot the issues early and frame the choices and understand why just pay people for referrals is not a clean concept in the securities world. It's not a blueprint that you can copy and paste into your business though, because the details matter and the compliance architecture matters even more. An interval fund is a registered closed-end fund that generally does not trade on an exchange, continuously or periodically offers shares at NAV, and provides liquidity primarily through periodic repurchase offers rather than daily redemptions. Those repurchase offers are commonly quarterly, and the fund will typically repurchase only a limited percentage of the outstanding shares per offer. That structure creates two realities relevant to incentives. The first is distributions and communications that are central to the product. You're always essentially in offering mode, which means that a referral engine can look less like a marketing and more like compensated selling activity. Investors can misunderstand liquidity is the second piece. So in interval funds, the marketing risk is not just the performance hype, it's also the practical mechanics of repurchases, pro rata limits, and how long capital can be tied up. So if you're building a referral program around an interval fund, you are not just designing growth, you are designing a regulated distribution behavior. Most referral programs in this space get tangled because they implicate three overlapping buckets. One is broker-dealer registration and the whole finder's fee problem. The Exchange Act, Section 15A, right? The SEC's broker-dealer registration guide frames this core point simply. Section 15A generally makes it unlawful for a broker or a dealer to use interstate means to effect transactions or induce purchases or sales of securities unless registered, subject to limited exceptions. The guide also lays out questions that the SEC looks at when assessing whether someone is acting as a broker. Two of the obvious ones are, do you participate in important parts of a securities transaction? Solicitation, negotiation, execution. And another is your compensation tied to the outcome or size of the transaction, including trailing commissions or other transaction-related compensation? That is why pay a percentage of AUM or pay only if the investor invests strategy is so radioactive. Even if the promoter thinks they are just a finder, the economics can look like sales compensation tied to a securities transaction. Also worth stating clearly is that private placement activity is not automatically exempt for broker-dealer registration. The SEC has explicitly noted that even if the underlying securities are sold under an exemption from the Securities Act, the intermediary can still have broker-dealer registration obligations. The next big thing is the investment advisor marketing rule, Rule 2064-1. If an investment advisor, including an advisor to a fund, is using compensated promoters, testimonials, or endorsements, the analysis usually runs straight into the marketing rule. The SEC's Small Entity Compliance Guide summarizes the key conditions for testimonials and endorsements. The first is disclosure, clear and prominent disclosure of whether the promoter is a client and whether the promoter is compensated, plus additional disclosures regarding compensation, conflicts, subject to limited exceptions in certain circumstances. The next is oversight and written agreements. So advisors must oversee compliance and then must enter into a written agreement with the promoters unless an exception applies, including affiliate promoters or de minimis compensation of like $1,000 or less in the preceding 12 months. Disqualification is another hurdle. The certain bad actor disqualifications. These are folks that cannot be compensated promoters and they're subject to exceptions where disqualification regimes apply. The SEC staff marketing compliance FAQs were updated on January 15th, 2026, which matters because the staff's views are evolving every day as they see more real-world marketing programs in play and they identify patterns in the marketplace. And the SEC's Division of Examinations issued a December 16, 2025 risk alert highlighting compliance observations tied to disclosures, oversight, third-party ratings, and other issues under the marketing rule. The translation is that if you're paying people to promote your platform, your advisor brand, or your fund, you should assume that the SEC expects real compliance and a real program, not just marketing copy. The offering rules and general solicitation risk is real. Referral programs can also collide with how you are offering the product in the first place. Are you registering the offering versus, is this an exempt offering, accredited versus non-accredited? All of this needs to be communicated publicly in the right way. And even when founders focus only on finder's fee regulations, the marketing execution can drift into public-facing communications that create a separate offering issue. The correct analysis always depends heavily on the offering path, the audience, and the distribution model. And then some people will say, but aren't there finder fee exemptions, right? This is one of the most common misconceptions. In October 2020, the SEC proposed a conditional exemption that would have created Tier 1 and Tier 2 finders for certain limited activities involving accredited investors subject to certain conditions. However, a critical point for 2026 planning is that the 2020 finders proposal was never adopted. So Commissioner remarks in 2025 explicitly note that the proposal was not finalized. So as a practical matter, you cannot build a business program assuming that you can fit into the SEC's proposed finder rule. There's no finalized federal finder safe harbor that you can simply claim, and the analysis goes back to the facts and circumstances analysis under Section 15A plus any applicable state law overlays. The growth compliance design problem is another issue. So what regulators care about is when you strip the terminology away, there's two main focuses. Who is doing what? A referral program is safer when the promoter's role is limited to something like introductions and the promoter isn't soliciting or persuading, discussing investment merits, valuation, or suitability, handling customer funds or paperwork, negotiating anything about the transaction or the deal, and holding themselves out as selling securities. The more the promoter behaves like a salesperson, the more the program starts to look like broker activity. Compensation design is often another decisive factor. Compensation tied to the size or success of a securities transaction is a classic red flag. The SEC's broker-dealer guide explicitly calls out transaction-related compensation and involvement in the transaction process as a key consideration. On the advisor side, once compensation is involved and the activity is a testimonial or endorsement, you are in marketing rule territory, which brings disclosure, oversight, agreements, and disqualification diligence into scope. A practical way to think about compliant referral program lanes is that most workable programs fit into one or a combination of the following lanes. Lane A is brand marketing endorsements. Marketing rule first kind of issues. This is the influencer or ambassador lane. If you're paying someone to promote the advisor, the platform, or the fund in public content, then you should assume that you need the promoter agreements in place, unless there's an exception. You need compliant disclosures, compensation conflicts, status. You need monitoring and supervision. And you need documentation and record keeping that can stand up in an exam. This lane can work, but it's not lightweight. Now, lane B, lead generation. So this is the broker-dealer analysis first issue. So this is the I will introduce you to people lane. If compensation is contingent on investments closing or tied to dollars invested or tied to transaction outcomes, the risk of the promoter being viewed as acting as an unregistered broker increases materially. Programs in this lane need careful boundaries around activities, compensation, scripts, training, and monitoring. And often the cleanest solution is partnering with a registered broker-dealer where the facts call for it, rather than trying to engineer around the broker definition. Lane C is formal distribution through regulated channels. This is the structure first analysis. So for some models, the right answer is not make the referral program more clever. The right answer is make the distribution architecture correct. So that can mean working with registered intermediaries, using the right agreements, aligning the compensation and supervision with regulated frameworks that already exist for selling securities. The best founders I work with treat this as a product decision, not merely as a legal constraint. The common mistakes that blow up otherwise good ideas that I see over and over again is paying per investment, paying per dollar invested, or paying trails, transaction-linked comp. That's exactly what regulators focus on when evaluating broker activity. Letting promoters explain the fund in their own words is not a great idea. That is how marketing becomes solicitation and how compliance becomes unmanageable. Social media endorsements with no real disclosures are also high risk. The SEC has repeatedly emphasized that disclosure and substantiation expectations in marketing rule exams and enforcement. Another issue is assuming that the finder exemption exists when it doesn't, at least not as a finalized SEC rule. Treating compliance as a document instead of a system is also a problem. The SEC's December 2025 observations highlight that oversight compliance practices are a recurring exam theme. All right, as a final thought, you can absolutely build a referral and incentive program in the securities space. There's usually a compliant and commercially viable way to do it, but you cannot responsibly implement a referral program for an interval fund or advisor platform using a generic blog post or a great video. Even a really, really great video, a template agreement, or what worked for a non-regulated app. The right structure depends on the product, the distribution model, the audience, the compensation mechanics, the messaging, and the compliance infrastructure that you are willing to operate under. If you're considering a referral program, a finder fee structure, or a compensated endorsement strategy for a fund, fintech, or a registered investment advisor, talk to a securities lawyer or talk to me before you ship it. If you want to pressure test an idea, sanity check a compensation design, or map to a compliant program that still drives growth, you can reach me at gesmer.com, or you can send me an email. That's all for now. Thanks for watching. My name is Braeden Anderson. I'm a partner at Gesmer Updegrove. See you next time.